So good morning, everyone. Good morning, Mr. Richard Wee, my fellow colleagues, students, ladies and gentlemen. I'm pleased to be with you today morning in conjunction with Professional Development Week. This is the third of a series of talks that we've held this week in the law school. And I have a chance to introduce our guest speaker today morning, Mr. Richard Wee, partner of Richard Wee and Chambers, who will be speaking to us on a career in civil litigation. Mr. Richard Wee was called to the Malaysian bar in 1999. In the early days of his career, he specialized in litigation, and over the last 20 years has built a reputation for dispute resolution, appearing in every level of courts in Peninsular Malaysia, as well as various tribunals and arbitration matters. Mr. Richard Wee has pioneered for the expansion and improvement of sports law and esports in Malaysia. He not only co-founded the Sports Law Association of Malaysia in 2016, but over the years has organized several annual sports law conferences. An avid sports and technology enthusiast with legal know-how, Mr. Richard Wee is sought after, and his unique position has seen him be elected to the Appeal Committee of the National Disputes Resolution Chambers by FIFA and the Football Association of Malaysia in 2019. He was subsequently appointed to the advisory panel of experts by the Ministry of Youth and Sports in 2020. And recently in 2021, Mr. Richard Wee was appointed as members of the panel of experts in the Research and Development Fund for Technology by the Ministry of Science, Technology and Innovation. Committed to serving and teaching others, Mr. Richard has continued to serve at the Malaysian Bar and Kuala Lumpur Bar over the last 15 years in various capacity. Mr. Richard Wee had started his earlier career as a lecturer, and with teaching in his blood, has continued to conduct training and seminars all over Malaysia and has been invited to speak at various universities and colleges on the area of law. Without further ado, ladies and gentlemen, please join me in welcoming Mr. Richard Wee.
Thank you so much, Marini. Much obliged. Firstly, to all my fellow Muslim participants, Selamat Raya. Maaf Zahir Batin. I hope the lemang wasn't too overwhelming and you stay awake for the next 1 hour or so. Number one, I would like to thank Taylor's, Marini and your team for having me. It's always nice to come back to universities to share some views. And I would like to acknowledge my colleagues, Miss Sabrina, who prepared the slides, and Miss Camelia, who is now managing the slides to click next for me, and my colleagues in RWC, Miss Atira and our pupil, mentor pupil, Miss Wong Ziying, who managed this event. Thank you very much. Now, I've been in practice since 1999, and some small fact for you all. I think your I'm not sure what is the title, but it's a dean, Professor Kong Kok Wei, right? His name is Kong Kok Wei, right? Yeah. He and I are Standard 1 classmates. You know, we were classmates in Standard 1, 2, and 3. So I never thought that one day, many years later, I'll be giving a lecture at his workplace, you know. So Kok Wai, if you're there, hi, you know, morning. I still call him Kok Wai. Okay. Now, career in civil litigation. Civil litigation is one of the three major litigation areas in Malaysia. The other one is being criminal litigation, and the third one is, of course, now very popular, arbitration. But it is just a different platform for you to argue your case, defend your client, submit your points, but the skills are more or less the same. Of course, with criminal litigation, there is an element of ambush tactic, thinking on your feet and submitting and arguing your way out. And tactically in criminal litigation, your strategy is to raise some reasonable doubts, which may suffice in persuading the judge that your client should be acquitted. In my career, I've done all three, particularly civil and criminal. I had I'm not sure whether it's fortunate or unfortunate, but to defend clients for drug offenses which carry death penalty. And it was very daunting to do that. Thank God, every case that we were engaged, we won. And for criminal work, I have my personal aspiration is that I do legal aid work. I don't really take up fee earning work for criminal fees. Criminal work, I just want to help wherever I can. And under the law, when a person is charged for a capital offense, a lawyer is mandatory to represent the person. So there, my name is listed as one of the lawyers to represent in the criminal litigation. So that's criminal, right? But today's about civil litigation. I remembered my first day in practice after being called to the bar. 9 months of chambering, all I did was paperwork, solicitors work, banking litigation, and it was boring, but actually it set the foundation and the terms of my experience. I didn't feel that it was boring at all. In fact, I thought it was very interesting, the 9 months. But for many of my friends, they say, banking litigation in 9 months is the same thing. But actually set the tone on how to file a suit, where to file a suit, the documentation process, the strategic thinking, etc., etc. And then when I got called to the bar in 1999, my first law firm I was working at for 4 years, I did mostly personal injury and accident cases. I wanted to join that kind of firm back then because that kind of firm has trials every day. So true enough, I was exposed to hearings, trials, and appeals every week for many years. And then I established my own law firm in 2003. And since 2003 until now, I have been managing my own firm. So next slide. Please. Okay, thanks, Emir. So these are the topics we'll be talking about. Career, our court hierarchy. You need to know the court hierarchy to do civil litigation. What knowledge and skills you need to have, resources, practical knowledge and skills, trial experience, hearing application, case management. So I'll touch and go here very fast. Now, what I'm trying to do here is to share my personal experiences, but I try to make it as general as we can. I do not believe that my experience is the universal experience. And some of my experiences could be peculiar to the way we litigate, peculiar to the kind of cases that I have. Maybe if you meet some other litigators, they may have a slightly different strategic approach or tactical approach. So I'm trying to make this as general as I can. And then hopefully this will inspire you to read up more, understand more, and observe how the other litigation lawyers work for you to sharpen your skills and improve yourself. Now, career litigation, next. Thank you. Next again, yeah. Nice picture. So basically, these are the three generally in Malaysia, these are three areas of civil litigation, the practice itself. The first one, obviously, is the counsel. In the United Kingdom, we would refer to this as barrister. But in Malaysia, as you know, we are a fused profession. Even our business cards refer to us as advocates and solicitors. So the advocate part is actually counsel lah, barrister lah. So this is where you advocate for the matter, go to court, argue a case. Solicitors work, most of us have to go through that first. In order to become a barrister, you need to know how to prepare your file, compile your documents, teamwork, learn to do team work with the team, sharpen your drafting skills, and very important and underrated is the organizational skills. You really need to learn to be organized because you don't just manage one file. Chances are when any of you get called to the bar and join the legal practice, you probably be handling quite a number of files. And I recall when I was a young advocate and solicitor back in 1999 and 2000, I was having teh tarik with my colleague after work, and we had a discussion on how many cases each of us were managing. And I just realized at that evening that I was running 100 cases and he was running about 120 cases. So that explained why we were in office every day, including Chinese New Year and Raya and Deepavali. So that is skills that you must have, the 5. Research assistant may not necessarily be an intern or pupil or paralegal. Some lawyers are very good at research. The skills, the way they sift through, nowadays is LexisNexis, of course, and Westlaw, etc. But of course, in my days, my time, research means going to library, sitting there for hours and being good friends with the photocopy machine. but the things are now speedier, and the skills are slightly different. But the end game is to find the relevant authority or cases or materials to support what you want to submit in court. So these are the three careers. Next, please. So this is a normal day in the life of a civil litigation lawyer. You have certain cases come in brand new, so you have to do case assessment, investigation, sometimes forensic. So that's why you need to work in a team. Some firms I know is a sole proprietor, and those are normally either criminal litigation lawyers, or those are the firms who do simple and standard civil litigation work. Then drafting pleadings, daily work. Discovery process, which is going through the documents, daily work. Pre-trial tasks. This is where if you know a trial is coming up, then you have to interview your witnesses, identify your issues, narrow down the topics, and then start exposing your witnesses to the potential cross-examination question. No coaching. One thing is for sure, when you coach your witnesses in court, the judge can easily see that the witness has been coached. So you can then, instead of coaching, the tactic we do is we expose. So sometimes what I do when I interview my witnesses, I purposely cross-examine as if I'm my opponent. So some of my witnesses get very upset, say, oh, come on, man, Richard, you're my lawyer. I say, yeah, but in court, I won't be the only lawyer talking with you. The other lawyer is prepared to darken your what do you call this, character as much as they can. They'll destroy your case as much as you can. So why don't I now expose you what I think they will ask you? Then let that witness come up and formulate their own answer. And then usually 99% of the time, when the witness formulate their own answer, they will remember. And at trial, which is about 6 months or 1 year from now, that witness will naturally answer that way. It looks natural. This process takes a lot of time, but it is effective, and your credibility before the judge is upheld, because the judge knows that you're not coaching your witness, and usually the witness also look very credible. Okay. Now, of course, trial is, of course, you need to learn, is an on-the-job training. No matter how many classes you go, much training you go, trials is on-the-job training. And I recall my first trial ever, I was alone. I walked into the courtroom alone. So let me tell you what I did. A few weeks before the trial, I knew I was going to be at the court alone. And I actually had to go to court one day for certain mentions. And then I visited one courtroom after another to look for a courtroom which was conducting a trial. And true enough, there was a courtroom having a trial. So I walked in, sat at the back, and watched a trial for 1 hour to see how they conducted the trial. That was way back in the early 2000s. And then eventually, when I did my trial, I was still fairly nervous being the first time. But my boss at the time, he felt that I could do it. Not sure whether he felt I could do it, or maybe he didn't want to do it and gave me the file. I don't know. But nevertheless, it was daunting, but much impactful experience, which I remember until now. So, and my first trial, ironically, despite I was practicing in Klang Valley, was in Malacca, where I held my trial in Malacca, where the judge eventually, after the trial, after crossing swords with him and the opponent, who happened to be a very senior lawyer in Malacca, they all became my friends. They're still my friends until now, actually. So the judge has retired, and when he sees me, he still calls me, and I still call him Yang Arif, Tuan Hakim. It's like I said, it's an impactful experience. Then, of course, there's always a possibility of settlement. The irony is, when we do a litigation, we try to settle the matter, evade trial as much as you can. Trial should be the last option. And of course, plans for appeal. If you win or lose, you may want to appeal if you lose, and you may have to face an appeal if you win. Next. So this is the court hierarchy. I think you all have been exposed to this in Taylor's University. So I'll make it very quickly. This the structure in the Malaysian court. Right on top is the federal court or the special courts. The special courts is the one we create based on the constitution, particularly to charge royalties. Then there's the federal court, the Court of Appeal, and then the High Court of Malay and Sabah and Sarawak, Sessions and Magistrate. So this is our court hierarchy. Outside this triangular, a totally different area is arbitration, which I'm not going in today, because arbitration is more lateral. You go in, you submit your case, get an award, and then if you are unhappy, you file in High Court of Malaya to review your decision. So in the end, you still come back here, right? Okay, next. So these are, after looking at my personal experience and speaking to my colleagues, speaking to my fellow counterparts, who most of them are around my seniority, these are the three things I think you need to know. You need to have advocacy and research skills. You need to understand the matter, and you need to have knowledge of that area of law. So it is very important. I know that phrase, you keep on hearing this phrase, it is very important. It is very important. Most lawyers will say that, but it's true. It is very important that you need to read your law every day. Every day. Completion of your LLB is merely obtaining a driving license from JPJ. After that, as we all know, you don't become an expert driver. You need to drive for a long time to be experienced driver. And unfortunately, as you know, a person may be driving for 20 years and still get into an accident. So that's why, to me, being a lawyer is a lifelong reading and acquisition of knowledge. Now you may say, oh my God, what did I get myself into, man? I thought once I finish it, that's it, I can chill and lep out. No. Now let me ask you this question. If you walk into a clinic because you're not feeling well and you meet a doctor, and the doctor is still using equipment from 1975 and talking to you based on knowledge of medical from 1980, I wonder how you feel when you walk into such a clinic, right? Even when you go into certain businesses and the businesses don't use Shopee or don't use Lazada, don't use e-commerce, never heard of Grab, never heard of Food Panda, you look at that person and where have you been, mate? So imagine you feel like that, right? You feel like that when you see, you meet such a person, meet such a doctor. So imagine if someone goes into your law office and you're still talking about Kala against Kabalik smoke balls, thinking that you're still living in the 1800s, and all lawyers are still riding on horses, and LexisNexis doesn't exist. So can you imagine that if a client look at you and say, what is wrong with this lawyer? So if you expect the latest businesses to embrace e-commerce, deliver stuff to your house and your door, you want doctors to be on the ball, so must you, because we are professionals. And as a professional, you need to always improve. Look at the famous football players, Lionel Messi, Cristiano Ronaldo. Look at the top tennis players, Serena Williams. They are right on top, yet they coach and train every day, 6 to 10 hours. What for? They're on top, but yet they train and sharpen their skills every day. So if they do that, why must you stop after you obtain your LLB? Think about that. I'm not telling you, I want you to think about that and ponder about what you're getting into, the profession that you're coming into. Remember, you're not joining a job, This is not a job. This is a profession. Ask the question, why is it called a profession, not legal job? Even the Act of Parliament is called Legal Profession Act, not Legal Job Act. It doesn't say that. Think about it. Why is it called a profession? Okay, so these are the three things I feel you all need to keep an eye on. Next, please. I think we are coming to an end soon. These are the resources that you must have. Constantly have access to books, case laws, and statutes. Case laws are easy now. You can have acquire licenses to the online cases and statutes too. Books, I would propose, notwithstanding Kindle and whatever, please buy books. Nothing beats having this, holding this. As you can see, I'm sitting next to books. I'm in my room full of books. So I'm in my house, yet I'm full of books. If you come to my office, my room that I'm sitting in I'm surrounded by books. And my law firm, every corner have books. So that's important. And we constantly invest in acquiring books, notwithstanding everything is online. So you need to constantly read and update yourself. Okay, next. These are the statutes in Malaysia. So for those of you who are going to practice in Malaysia, you need to get used to acquiring such statutes. Malaysia, unlike the British common law, is heavily based on statutes. We were born in 1957, and then in Malaysia was born in 1963. When we were created in 1963, we are basically a statute-based country. Common law is strong, statute is equally strong. But if those who do British law, in England, common law very, very influential in deciding the law. I mean, look at our contract law. We don't study Contract Act, we study Carlisle. Our tort law, we don't study law, some Act of Parliament for tort. Instead, we study Donoghue and Stevenson, Caparo and Dickman, Wine and Jones. So Hadley Burn, So must know your statutes in Malaysia. Okay. Next, please. So these are things which, to me, very important for a civil litigation lawyer. And actually, the most important of these three is understanding the end game. So for me, this is peculiar to my style. And some of my friends, they were surprised that this is the way I've been practicing for 20 years. Whenever I take on a case, I actually look at the end game, how I want to end this case. Of course, we want to win. Everybody wants to win. But some cases are just not winnable. And so if it's not winnable, I tell my client, look, I don't think you're going to win this case. Do you still want to pay fees to me to lose the case? So sometimes strategically, the client said, look, Richard, I have no choice. I need to litigate this case for a few more months because I still can't settle this matter. So those are for financial matters where there's money involved. Then there's some disputes where, it's a tactical move. They need to delay the matter, or they need to lengthen the matter so that they buy more time. So we need to know, what is the purpose of this litigation? What do you want to litigate this matter? Winning and losing is obvious. Everybody wants to win, right? Then you work backwards. Once you know how you want to end the game, which could be 2 or 3 possibilities, then you work backwards. The tactics and all that is built towards that. And of course, the way to do it is to ensure your opponent don't really know where you are going. To leave red herrings, not to expose your tactics too much. But unfortunately for me, because I've been in practice for quite a while, whenever I go up against an opponent, they say, oh, it's Richard. Oh, okay. I roughly know how he's going to run the case. So like now when I have a case, I always ask my colleagues, they come to me and say, Richard, boss, we have a case. Who's our opponent? My question. They say, oh, so and so. I know her. I know him. This is how he's going to do the case. Blah, 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 blah. And true enough, that was how he or she do the case. So there's experience and knowledge. So for me, I try to still maintain flexibility. Sometimes I take a direct impact on purpose. I just go for it. So my opponent's like, hey, this is not Richard's style, but so I go for it because that's to shake the case. And I need that to win my case, to give my client time. Yeah? So everything we do is for the client. So these are just an example of the practical knowledge and skills of civil litigation. Next, please. Okay, now we're going to go through trials, hearing, and appeals. So for trials, these are the areas which is on my mind when we do the work. My colleagues and I who do trial, we have I think we mentioned a little bit earlier. This is in detail. There's a strategy and plan for trial, who to call, which witness, which is the better one, which document to refer to. So that's where due diligence and forensic of documents are important. Compiling relevant documents. So some documents we put into trial, some documents are irrelevant, so we don't put it in. Of course, we must interview the witnesses. After a while, we realize some witnesses may be irrelevant. Preparation for trial, you really need to read and memorize. My style is I like to draw on a few pieces of paper, the slides, so not slides, sorry, a chart on the case. I write down what I want to do. Those days, this is my way, but nowadays that paper is in my head. So when I see a case in my head, I really can draw left and right. But I've been in practice for 20 over years. So if I still need to write down, then maybe there's something wrong with me. But that's how I do. But in certain cases, I still, despite so many years in practice, I still take a piece of paper and write it down. And my favorite is drawing on a whiteboard. I have a permanent whiteboard in my room. In fact, my office have 4 or 5 whiteboards. We have whiteboards all over the office. And I encourage my colleagues to always discuss using the whiteboard, because that is a big picture argument. On the whiteboard, you see the big picture. Then you slowly narrow down what you need to plan. And it helps. I told my lawyers, technology is cool, but analog is always awesome. So analog ways can make you remember very well. Digital always makes it fast. So these are examples of things we do, right? Next, please. So hearing application. Hearing is where you file an application in court. For example, summary judgment. You want to apply to strike out. So there's a certain strategy. You file affidavits. While you say in affidavit, how you write the affidavit, what documents you compile to attach the affidavit, and then in court, how do you submit? I can share with you. For example, when we want to apply to, say, obtain summary judgment. So summary judgment is where you argue before the judge to say that the plaintiff's case is so clear and obvious that a trial is not needed. So how I would start is that this is how I say, my lord, much obliged, I'm Richard B. for the plaintiff. My lord, for today's application, the plaintiff is seeking a summary judgment. It is our contention and our submission that our case is clear and obvious. So clear, so obvious that a trial is not needed. Yes, there are some issues that my learned friend will raise, and they will try to submit that there are triable issues that require a trial. But at the end of the day, your lordship will see those are merely minute issues. The big picture is the plaintiff's case is clear and obvious. Then blah, 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 blah. That's how you submit, for example. So, of course, hearing applications, we have High Court, Court of Appeal, Federal Court. Even Court of Appeal, we have applications. In Federal Court, we have applications too. The skills are a bit different as compared to conducting a trial. Next. So these are, for hearing application, you need to plan your submissions. You prepare a bundle of authority. So cases are very important. If you're doing appeal, then you need to understand the record of appeal. The record of appeal is the compilation of all the documents in the lower court, which is now compiled, put into a bundle, which is usually this thick, sometimes this volume. I remember going to court carrying 2-3 boxes, and the big luggage that I carry to go to Europe for holiday, I use that to put my files to go to court. That is a life of a civil litigation lawyer. Then, of course, submissions. Sometimes the judge will say, yeah, Richard, I've read your written submissions. I don't need any more. I will decide next week. Sometimes the judge say, oh, Mr. Richard, I want you to submit on this point. So you submit. Sometimes some judges say, okay, Richard, talk. So then we talk. And that's where lawyers love to talk. So some lawyers can talk and talk and talk and talk and talk. I think lawyers are the only people who can talk to a dead person. The dead person may wake up and tell the person, can you please keep quiet, I want to die. Because really, some lawyers can really talk. So that's one of our skills. Unfortunately, it's a skill which we need to talk. But It's actually not speaking skills, it's not talking skills. It is advocacy skills, skills of persuasion. Actually, all your teachers, your lecturers have these skills. They need to persuade you that what they're teaching makes sense. And many of them will have gone through research, plan, and figure out what is the easiest way to teach you color against public smoke balls without confusing you. For example, if you're studying law of trust is such an abstract topic. I mean, what the hell is resulting trust, for example? So I personally love law of trust. But when I was a student, it was confusing. And I can tell you the teachers will take some time to plan and think how to tell you. Some of them, even though they've been teaching for years, would have still thought about it while driving to Taylor's, thinking, so today how, what tactic I want to teach them, you know? So these are all skills. And actually, your teachers are already a perfect example of advocacy skills, except that their advocacy is towards sharing knowledge with you, right? Now, of course, teamwork, most law firms, mine is also not uh, excluded. We are a team, RWC, for example, we have about 8 to 10 lawyers now. And every file, we have at least 2 or 3 lawyers running the file. So it's important to work together. And it's quite difficult to run a litigation matter alone nowadays. With the expansion of the way court work, teamwork is important. Next, case management. Now, case management is where you need to attend every now and then, appear before the judge and explain to his lordship or her ladyship what is happening to the case, because you're preparing towards trial. So case management is a good learning place for young lawyers, but highly underestimated, because many of them will say, tomorrow I got case management, and then go there and talk nonsense and come back. When I was doing case management, those days it was called summon for direction under Order 25. Then sometime in 2002, they amended the law to become case management. Case management for me was a perfect opportunity for me to read up and understand that brief before I appear before the judge. And every time I read preparing for case management, it sharpened my knowledge on that matter, made my memorizing ability better. And by the time I reached trial, I was ready. And also, case management is your chance to persuade the judge. So when you go for case management, every time before you appear before the judge is already an opportunity to try and win your case. So you try and say things which may make your judge like, So many months later, when he or she listens to your case, they will remember and say, yeah, Richard said this, you know. So you're actually planting thoughts into this head, similar to that movie, Inception. So you're already planting things. That is tactic. You don't study this. Your law school won't teach you this. They can't, because law schools is meant for theory. So in practice, this is what we do. Every opportunity for you to win, you already plant thoughts in your judge in a nice, subtle way. And both the lawyers will be doing the same thing. So it's something you need to learn when you work. Okay, next. Okay, I think it's slightly hanging. So I see the word, admin work in, okay, this one is the most underestimated work of litigation. Everybody want to wear a suit, nice tie, walk in with Louis Vuitton shoes. I don't know what's the difference between Louis Vuitton shoe and Bata shoes. It's still shoes. But some lawyers I see must wear Louis Vuitton shoes. Then argue like, never mind. So at the end of the day, it's not what you wear, it's what you think. The content, like what Martin Luther King once said, it is the content of the character which is more important than the external factors of the person. Okay, so these things which you must learn. And compiling, photocopying, combining. When I was a chambering student, I purposely learned this. And when I had my own law firm, I could do all this myself. So these are skills which you need to learn, because you never know, you may have an urgent litigation and you're alone in office. So do not underestimate these skills. And all my interns and paralegal, some of them will give me the look. And I tell them, go and learn comb binding. Open the photostat machine and understand. They're like, what the hell? Then one day when the photostat machine breaks down, they automatically just open and solve it without realizing that many months ago we trained them to do that. So that's something which all of us, not all of you, all of us need to learn. Every part of civil litigation is important. From the tip of the spear at the federal court to the general compiling of the files in office. Every level is important. Okay, next. I think my colleagues' internet may have some problem. Last one. This is the last one. Pro bono. So pro bono is an important aspect of litigation. I encourage all law students, when you get called to the bar, please do not forget the David who is facing the Goliath. Every day there is a David against Goliath. Some Davids, they just need help, and not everything is about money. There's only so much Audis and BMWs you can buy. There's only so much Coach bag and Prada bags that you want to buy. At the end of the day, somebody just need to eat rice and they need help. So, and my firm, I'm proud, very proud to say that we maintain the pro bono department ever since I established my firm in 2003. Every year, we do pro bono work. We help whatever way we can. Of course, at the end of the day, I confess and concede we need to earn money. I need to pay the salaries of my lawyer. I need to earn money. We are not doing this for love and affection, but I still have love and affection for the people. And there are some people who just need our help. So remember that. And not only that, statutorily under Section 42(1)(ish) of the Legal Profession Act, the Malaysian Bar is empowered to make provision to promote a scheme whereby impecunious persons may be represented. You may have heard of this scheme in the bar. It's called the Legal Aid Program. And Taylor's is very well known running your own legal aid program. I know of that since I was a young lawyer chairman in 2005. You were then known as Taylor's College in SS15. You were already doing that. So well done to Taylor's. Maintain that. But this character, you must carry on when you become a lawyer. All right. That's it. I think that's all. Yes, finally. Open the Q&A, which I think is far more important than what I spoke the last 45 minutes. All yours, Marini. Thank you for giving me this 45 minutes.
Thank you, Richard, for speaking to my students. I hope that, and that was definitely something that the students needed to know with regards to civil litigation. I open the floor to questions to students. If you've got any questions, please turn on your video and direct your question to Mr. Richard Wee.
Thank you. Camilla, can you switch off our slides, please? Thank you very much, Camilla. Yeah, much obliged. Poor Camilla at home. No, she's in office today. Today's office. My firm is broken into two groups because of the COVID, to Team A, Team B, for purposes of security and safety. In case somebody get COVID, then the other team still survive. So it's like we are like Holocaust, you know. I am legend. Will Smith making sure nobody becomes zombies. Okay, I'm all ears. Go ahead, ask.
Hi, Mr. Richard. I'm Kiran. I'm final year student from Taylor's University. So my question is this, Mr. Richard. When I was doing my internship, basically, when I was settlement, for civil dispute, that's where normally we try to go to have a settlement, to go to a middle ground. So clients, our own clients will be giving one proposal of terms, but there is a very big chance that they change their mind or they suddenly go for different terms. And they want us to talk to the other firm to defer our terms of conditions. And in those scenarios, our reputation is at stake because the other party does not communicate with the clients, but to us. In those scenarios, how do you handle things? Like, because we work for the clients. So
that's a good, what do you call this, practical question, Nakiran. Firstly, I think when clients instruct us to settle, demand that they put into writing. If they don't put into writing, you put into writing and you email them back. Preferably use email. I know everybody love WhatsApp and Telegram. WhatsApp and Telegram can collapse anytime. Email won't. And you can archive your email and you can track your email. So whatever it is, email, which is now becoming an old-fashioned. My time, email was cool. Now email, people use WhatsApp. Yeah, WhatsApp is for fast purposes, but email them. Or really no choice, WhatsApp them and say, dear Mr. X, Madam X, this is your instructions. So if they change your mind, you say, look, this is what you say, right? Then if they insist in you calling the other side, when you speak to the other side, let them know. Call the other side, say, look, I'm sorry, Mr. X or Miss X. Your opponent, actually in the bar, we don't call each other Mr. lah. We just call by the name. So you call Richard. Hi, Richard, I'm Nakiran. Yes. Hey, Richard, I'm so sorry lah. My client changed their mind. Of course, Richard will be like, what the hell? All the 4-letter word will come out normal lah. Lawyers are very vulgar. We every day, the F word is normal in our practice. So what the hell? Okay, then after that, you tell him, sorry lah, Richard, I'm just doing my job. I'm just doing my job. Blah, blah, blah. So it's all managing. PR skills. How to manage and stay calm. Don't get angry. Not worth getting angry. There are many angry lawyers out there. Very unhealthy. Not good for you. Not good for the client. Bad for your reputation. More importantly, when you go home after work, you're still Nakiran. You're not a lawyer. So why you want to argue with your mom, your dad, your wife, your husband for what? You know, stay cool. Okay?
Thanks, Mr. Shet. That's enlightening. Thank you.
Any more questions?
Is there any further questions from the floor?
If you are shy, maybe you can put on the chat, send me privately. I can reply, no problem. I won't mention your name.
I can manage the chat actually. So if you just put it, if you all want to ask any questions, you can put it in the chat box and I'll read it out to Mr. Richard V. So while we, okay, so there's a question here from Lai. Knowing that our client is not likely to win a case, what are the other outcomes that we can resort to?
Well, Lai, good question. This, of course, is a case-to-case basis. I cannot give you a one-size-fit-all solution. But strategically speaking, when we have a losing case or a case which is 49%, that means good, but not good enough to win, you know. And then there's some hopeless case, sure, lose case, you know. Then number one, you manage your client's expectation. Then strategically look at what is the worst case scenario or what is the best you can get in the worst case scenario and work towards it. So, but more importantly is you may need to manage your client's expectation. But if the client is difficult and not responding, then discharge yourself. Discharge yourself. Tell him, I'm sorry, or tell her, I'm sorry. I don't think I can act for you because you're not listening to my advice. I think you can find a lawyer. Move on. It's okay. Don't forget, there are 30 million Malaysians and 20,000 lawyers. They can go and find the other 19,999 lawyers, but you still got 29.999 million potential clients. So it's okay. Right? That's how you must think. Be professional. Don't hard up. If the client is stubborn, walk away. But don't be so fast lah. Don't the client don't listen to you one time. Oh, I don't talk to you anymore. Walk away. Cannot lah, like that. You know, you also need to sek cho lah in Chinese. You know. That means you talk, explain. Try to persuade, and this fellow is still being difficult. And then after a few weeks, then you say, okay lah. I think this guy is an idiot. Won't listen to me anymore. Then you politely discharge yourself to the client. Maybe to be fair to the client, you are blocking the client's case, to be fair. Maybe you are not seeing things which could solve the matter. So maybe another lawyer with another idea could be better. At the end of the day, it's about the client. Of course, make sure the client pay your fees before you discharge. Next question. Thanks, Lily. Thanks, Lai. Yeah, thanks, Lai.
Any questions? Any other further questions?
I'm going to switch on the video to drink some water. Huh?
While we're waiting for a question from the students, let me ask a question to Mr. Richard Wee.
Sure, go ahead.
As a new lawyer, what do you think about building a rapport? When I used to be in practice, one of the skills that we sort of learned very quickly was to learn how to build a rapport with the court staff, with the court interpreters and the court clerks. Is this something that you still advocate and advise to young lawyers?
Oh, definitely.
As well?
Definitely. Notwithstanding the last 18 months where things are online, I think the rapport with court staff, court colleagues are very important. Don't just try to be nice to the judges. You should be nice to everyone. So I recall when I was a young pupil and a young lawyer, we were running from court to court. I think Marini, you know what I'm talking about. And we used to be very good friends with the interpreter of the court, which, notwithstanding the name of the job, interpreter, is actually the most important officer in court. And until now, I am pleased to say that some of the interpreters, when I walk in the court, they were like, hey, now it's Mr. Richard. Hey, Mr. Richard, long time no see. Some of them, I don't even recognize them anymore. But obviously, because of the genuinely nice rapport we had with them, and be genuine, don't be fake. You know, if you are that day you are having a bad day, try not to talk to the interpreter. But be nice. And I think generally human beings are nice people. When you talk to the court clerks, interpreter, officers, why be nasty? They're just doing their job. Yes, some of them are not good, some of them are not efficient, some of them are blur, some of them are themselves nasty, but you don't have to stoop to their level. Be a lawyer, stay above it. Maintain your class. Thanks, Marini. Good question. Oh, more
so Larry is also putting another question, is what does civil litigation entail? Is it a very broad area which covers tort, contract, company law, arbitration, etc.?
Well, civil litigation, of course, is the practice of arguing matters in court, basically litigation. And some lawyers, of course, many lawyers, in fact, specialize within certain areas of civil litigation. So there are some lawyers who do only banking matters, some do, say, fraud investigation, some do company law disputes only, some do medical negligence only, but they're all still civil litigation. So it's like, for example, driving a car, you have SUV, MPV, four-wheel drive, sedan, small car, big car, but they're all still cars. You're still driving. And different cars may have slightly different skills to drive, but it's all cars. So when you join a law firm, look for the law firm which offers, if you want to do litigation, offers general litigation, so you can learn some general litigation. And at the same time, you can learn some specific areas. So like in RWC, for example, we are a general litigation firm. We do quite a number of general litigation work. But because of our reputation in fintech, our reputation in employment, and of course our reputation in sports and esports, these four areas, we have quite a fair bit of litigation on these four areas, except fintech. Fintech more corporate than litigation. But you get well known for certain industry like tourism industry, shipping industry. But the law is the same. The law is still contract law, tort law, constitutional law, blah, blah, blah. So it's a combination of two, right? So I do sports, for example, but I still need to know contract, tort, trust, land, blah, 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 right? So that's basically it, Lei. I think before Lei was another question. Let me see. I think it's from Bu Cheng.
Yeah, Bu Cheng, yes.
I hope I pronounce your name correctly, Bu Cheng. To take masters in law, branch out in other fields like finance. Once you finish your LLB, the world is an oyster. LLB is a very powerful degree because it opens options to many things. One of it, of course, is to be a professor, to be a teacher, to be a educator. And then one is, of course, to be someone like me, a lawyer, you know. Then there's always joining insurance, joining regulatory bodies. In sports association, you can join many sports associations as a legal advisor, blah, blah, blah. Then doing masters, to me, it's a positive move forward. Personally, I wanted to do my masters. I tried, but time was against me. So I would not say it's a bad thing, but you need to have time to do it. And if you're going to do your masters, I would propose to do masters in areas which you can expand in your career. If you're going to be a researcher in artificial intelligence, for example, and you want to do law of AI, then do that. Then you go into deep into research. Or if you want to do you want to be expert in company law and you want to argue in court as a top company law lawyer, then maybe you want to do masters in law and company, etc., etc. CLP, of course, please finish your CLP. It is an extremely difficult exam. I remember in 1997, when I did my CLP, we had teh tarik at 2 a.m. in the morning. All of us came out, had soup kambing. Because soup kambing keeps you awake. You may not realize that. Soup kambing keeps you awake. So we at 2 a.m. in the morning. I remembered about 3 months before the exam, 4 of us sat down. This is way before COVID when we can go out. And we started counting how many cases we were memorizing. And that's where I realized that I have memorized more than 1,000 cases for CPC, Criminal Procedure Code. So CLP is a very difficult exam. But hey, guys, you're training to be a lawyer. This is I don't know whether you still realize, you're becoming a lawyer. This is a very unique and difficult profession. You are going to deal with people's problems and people's lives. People are going to come to you because their son is in prison because of certain drug matters. They come to you because the company has been cheated for millions of ringgit. They come to you because they found out that some politician stole 2.6 billion from a company and they need to forensic evidence to check it out, blah, blah, blah. So these are the things you must understand. Our jobs are very, very specialized and very special. We are not special. We are normal people, but the job is special. So that's why CLP needs to be tough. British bar exam is not cheap and not easy. Don't be seduced by the drinking at Lincoln Inn, My Inn, Your Inn, Holiday Inn. It's still a very difficult exam. Okay, and I know of people who fail the bar exam, right? So yes, do your CLP. Do your CLP.
Can I just add on to what Mr. Richard Wee was saying, to Bo Chang as well. I mean, once you finish your CLP and once you pass your CLP, I would advise and encourage you to then go on to do your chambering and get called to the Malaysian bar and wet your feet in practice before you make a decision or choose to make a decision to leave practice or go into another industry. But do make sure that you get called to the bar and get qualified. It adds weight and credential to your qualifications and your future. We have a couple more questions from students. Hello, sir, I'm Abe. From my internship experience, I've realized that sometimes it's very hard to be ethical in every situation. For example, cases that have political influence. So as a lawyer, how do you balance or how to balance?
Well, at the end of the day, Abir, it is actually the other way around. I think it is actually very easy to be ethical. Very, very easy to be ethical. Just do the right thing every time, every way. I'm not going to sugarcoat the situation. I know some law firms are quite prepared to do whatever they can for their paymasters, which may or may not include politicians. I have no comment about the way that law firm practice. But even then, at that moment in time, any lawyer at any situation can still choose to do the right thing. So I know you may think you may write that it's very difficult, and I can imagine the situation you're in. But try, Abir, to always remember that at the end of the day, our job is to always help the client and do the right thing. I mean, if a person come to me, Abir, and say that they want to buy and sell a property, and they want to try and get the property cheap, try to draft the S&P sale purchase agreement in such a way that the agreement will be one-sided to that client. Would you do that? You may say, no, I'll try to be fair, but that person is your client. So you do the right thing by helping your client, but you must also advise your client, guide your client, tell your client. And if it's very difficult to do the right thing, as I said earlier, discharge yourself. Don't do it. Leave. But if you still insist on doing, which means you're prepared to compromise, that's outside ethicality. Then you have to be prepared to face the consequences. Okay? Good question, Abir. Not easy to answer. I don't think I can give you a good answer, but to me, always try to do the right thing.
So,
Thank you,
actually,
sir.
Abir is actually based in Bangladesh right now. He's in Dhaka. And yeah,
okay.
so all our final semester students have actually completed 8 weeks of internship in January. So he speaks from his experience during the internship. For the Malaysian students, when you actually chamber, the Malaysian bar you'll have to go through an ethics course. I don't know whether that's still being done.
Oh yes, of course. I'm the chairman of the Professional Standards and Development Committee in the bar, Marini. So once in a while, we actually still have to check out the ethics class. And I am the guy who changed the ethics class from face-to-face to online. So 3 years ago, we changed it to online because we know that more and more pupils had difficulty going to attend classes for like 8 hours and affected their work. So we moved it online. So now it's like 70% online, 30% face-to-face. But luckily, because it's now online, so during COVID, none of our pupils were affected. None of them were, they just continue. So it was like a clairvoyant, unexpectedly clairvoyant, and we kind of resolved that problem way back in 2017. So, but yes, ethics must be there, yes, yeah.
We have one last question from the student. It's from Suhaila. She says, hello, Mr. Richard, I'm Putri. How long is your working hour a day as a lawyer?
Wow, this question, I think if I answer truthfully, Putri, you may leave the group and stop studying immediately. Okay, first, bear with me. I just need to say this for 30 seconds. I run my own firm. The firm, after all, I'm Richard Wee, and the name of the firm is Richard Wee Chambers. So you can kind of figure out who owns the firm. So when you manage and own a firm, it's virtually a 24 hours job. I think even when I sleep, I dream about the firm. So as a lawyer, and I think Miss Marini will know because she practiced before. Practice is, a lawyer is like a fireman. You never heard of a fireman who is not ready. Firemen sit down in the balai bomba. They may play games, watch TV, but they're always ready. And nobody ever calls a fireman and say, Mr. Fireman, there'll be a fire tomorrow. Can you come at 5 o'clock? Nobody does that. When they get a phone call, they have to jump and get out on the spot, which means the fireman must be prepared and ready 24 hours. Lawyers are the same. No client is going to call you and says, Richard, I'm going to get arrested for drugs next week. Can you be ready? So next week when they arrest me, you come and help me. You know, whenever we get a phone call from a client, it means they are already in trouble. Or if it's a corporate matter, when they call you, means they are already in the deal. They are already starting the work. They need you to come and finalize the matter. For me, it's almost the whole day. But for my colleagues, we maintain a 9 to 6 job. We don't work too late in the day. Now, of course, because of online, our online work, we do meet up middle of night sometimes to discuss our cases because we can't meet in office. We don't work on weekends if possible. We discourage our lawyers from working in a weekend. You can ask my lawyers who are here. Some of them are here now. We try to maintain a 5-day, 2-day work, 5 days non-stop work, 2 days, Saturday, Sunday, chill and lepak. But we do sometimes have no choice to go into office on Sunday because we have a trial on Monday. So we have no choice to go to office on a Sunday to get ready. It happens lah. So generally for associates and the pupils, they work from 9 to maybe 7 p.m. and 8 p.m. They go home for dinner. Some of them, they come to office at 10 a.m. because, you know, they work late at night. But for me, it's the whole day. So like today, after you, I have a meeting at 1, I have a meeting at 2:30, and I have a meeting at 4. Just today. And then in the evening, I need to meet, and these are just meeting clients. I still need to meet my lawyers. So we're going to have a team meeting later to discuss our work. Every day we have a team meeting online. It's my life. Yeah. So that's the answer to the question.
So we've already come towards the end of today's session. I think there's just another question here on the chat box. Do law firms usually prefer performance coaches with some kind of background in law?
Now, Vashika, it is a good question because I think some law firms are now looking at coaches, engaging coaches to come and coach the lawyers. Being a mentor, being a trainer, being a master, being a boss is one thing, but being a coach is another thing. Now, personally, my firm, we were talking about trainers and coaches coming in to coach our lawyers, but that was before COVID. So since COVID came in, we decided not to do it. It's very difficult to coach online. And but yes, if a person is going to be coaching a law firm, lawyers, then preferably the coach should be a lawyer. But personally, I feel bosses and partners can be coaches, provided they stop thinking of scolding the lawyer all the time. You know, most partners they think coaching is scolding, which is wrong. Imagine again like a football player or a tennis player. Coaching is sharpening and honing the skills. So they keep on kicking and hitting the ball until they get it right. That's coaching. But if the partner go there and shout at the lawyer every day, it's not coaching. But some partners I know for a fact can be very good coaches. They can coach the player, can coach the lawyer. So yes, preferably the coach is a law with a law background. Thank you for asking the question.
So I've just got one question before we end the session. I hope you don't mind, Richard.
Sure.
As a pioneer for esports and sports law in Malaysia, what do you think about? I mean, what do you think would be an upcoming area of litigation in the future?
I again just sharing experience. I'm not at all trying to be boastful, and I was wrong in certain areas. Way back in 2007 and 8, at the time I was the chair of the young lawyers. I was asked a question, and I was reviewing what to do for my colleagues who were all young lawyers. What is the future? And I told them arbitration. Look at arbitration. Look at construction. I also thought that shipping will be a big thing, but it didn't. Shipping still remained a very niche and close area. It didn't really become, because I thought shipping would be big because we had a new port in Kuantan. Of course, we have Klang and we have Penang, and don't forget we have a Tanjung Pelepas in Johor, and then in Kota Kinabalu they were opening a port, and of course Kuching always had a port. So I thought shipping would be a big thing, but it didn't. So I was wrong there. But arbitration and construction became very big. So now moving on to now, I remember in 2015, I told my friends, watch out for sports and esports. And it's growing now. It's growing now. I think for now, Marini, I would put my bet on fintech, technology issues, technology issues, startups, regulatory matters. So when you do startups and fintech, you need to know regulation. So RWC, for example, we do quite a number of fintech work, and it's all about down to regulations and advising the client on the regulatory aspects of their work. Startups, of course, startup is just a young company, but most we use the word startup for those who are into technology. They have a certain kind of technology, and not all are fintech. Some are just normal social media technology. Some are maybe networking technology, or B2B, business to business technology. I think that area will have disputes eventually, and we will see that in litigation. But one thing's for sure, the traditional litigation will always be there, Marini. Tort, personal injury, criminal, company, banking, contractual dispute, family disputes, disputes about wills and succession, divorce matters, family matters, adoption. That one is evergreen. It's going to be there for, I would dare say, for forever. Yeah, but if you're talking about new areas, I think technology, startups, and fintech. Hopefully,
Thank you, Richard. Well, we can already see there's an interest. The university actually offers a fintech as a minor, and we do have a couple of students who've chosen to take up minor in a fintech as well, knowing that this could possibly be the future as well. So we've come to the end of today's session. I would like to thank Mr. Richard Wee for speaking to our students today morning. I'm sure the students have been well educated on at least the start of civil litigation in Peninsular Malaysia, as well as in Sabah and Sarawak, and a career in civil litigation. For the students in semester 6, the session, I will stay on in the session for a couple more minutes so that you're able to fill up the attendance form that is on the chat box. To everyone else, thank you very much. And thank you, Richard, for speaking to our students today morning.
Okay, thank you for having me, and all of you. My last words is that it is crucial you understand what you're getting into. Civil litigation is just one part of our work. Please go back and ponder what I said, the legal profession. Read more about that and understand what you're getting into. Good luck to you. May the force be with you. I keep on seeing Marini's Darth Vader, so I now thought, may the force be with you. Take care. I will leave the room now. I'll leave the room now. Marini, so you don't mind, after this, can you share the video recording with us?
I will do. When I get the link, I'll send it to you.
Much obliged. Take care of yourself. Okay. Everybody, good luck. Take care. Bye-bye.